Hello, I'm Michael Davies. I'm a Spanish inheritance lawyer, and I've been handling wills, probate, inheritance, inheritance tax issues, inheritance-related litigation all over Spain, mainly for expats, since 1996. So most of my clients are families that have purchased a property somewhere in Spain and need help with their wills, or they're people that come to us because one of their loved ones has passed away having a property in Spain and they need help with the inheritance procedure. Sometimes, most times, with a Spanish will, but also on some occasions, unfortunately, there was no Spanish will, so we may need to deal with the Spanish estate using the English will if it's possible, after it gets probate obtained on it, or sometimes even there are intestate procedures. But in most cases, what we have are clients that come to us, we prepare their Spanish wills for them in the most tax efficient way, and then one day sometimes we end up going to probate on those wills that we've done. But we also do it for and go to probate on wills made by other colleagues of us, maybe when they handled the conveyance originally or whenever. So, regardless of whether you're thinking of buying a property in Spain, whether you're an expat living in Spain, or whether you simply own a property in Spain, there's one thing that you must do. This is my recommendation. I say I'm over 25 years handling probate over here, so I know there's a strong reason behind all this. Is you should make a Spanish will. Why should I make a Spanish will? Well, very simple. It's always recommendable to have one will in each country where you have assets. It just keeps things more straightforward. For example, if you have got assets in Spain, you haven't got a Spanish will, and you've made a will in the UK for worldwide assets, okay, if the worst comes to the worst, we'll have to wait for probate in the UK, and then I've got to convalidate it for use in Spain. It will cause all sorts of problems, and it will definitely be much more expensive, take a longer time, and the will may not have been made in a cost-efficient way for Spain. Plus, the English wills often mentions the word trust, and trust causes all sorts of problems here in Spain. So if you're in one of these problems and you need help with probate on English will in Spain, call us and we will deal with it. Bet you want to try and avoid this, mainly because of the high fees to us to sort out what essentially is a bit of a mess. Okay, so making a will in Spain is really straightforward. Most lawyers, when they handle the conveyance, at least in our firm, when our firm handles the conveyance of a property in Spain, we will recommend always make a Spanish will, okay? And soon after the purchase has been handled, we'll make a Spanish will. In Spain, we do them in 2 columns, English and Spanish, and they get registered in the Central Register of Wills in Madrid. And then basically with a straightforward will in Spain. Remember, in Spain now since 2015, you're allowed to choose your national law to determine how you're allowed to distribute your estate. And that has the advantage that you don't have to comply with the Spanish system of obligatory heirs like Spanish people do. Spanish people need to leave 2/3 of their estate down to their kids, and they don't have freedom like we do in the UK, for example, to leave everything to our spouse. But you can make a Spanish will in Spain and put this clause in that avoids the system of obligatory heirs. I'll take the opportunity to say that if you've got an old will made in Spain before 2015, definitely it's before 2012, a bit complicated to explain, but you probably should update your will. So for that, you can call us or call the lawyer that prepared it and ask them whether the will is compliant with Directive 650/2012, which is the one that came into force in 2015 and is the one that allows us to choose our national laws to determine how we're allowed to distribute our estate. So I had a bit rant on there, but basically the conclusion is make a Spanish will. So if you have assets in Spain, make the Spanish will. How do you do it? Well, if you didn't do one originally when you handled the conveyance, just give us a call, send us an email. We'll send you a quote for preparing your Spanish wills, which will basically be meeting one day at one of our offices or over Zoom and signing the new will 1 week later. If you've already got an existing will and you're simply not certain whether it's the best will possible for you, also give us a call. We'll organize a consultation, and Maria, my secretary, will send you an email with all the pricing and things, and we can organize a new will for you, if only if it's necessary. So with that out of the way, that's the business of the will. Obviously, during the appointment to discuss your wishes, obviously we will make sure that they're as tax efficient as possible. Inheritance tax varies a lot depending on the region of Spain where their assets are situated. So that all that needs to be taken into account when we're doing the wills. The good news for those of you that don't know when you're watching this video, Valencia and the Baleares have both joined Andalusia and greatly reduced inheritance tax for group 1 and 2 beneficiaries, which are basically spouse and direct descendants. That's children and grandchildren. The region of Madrid is also very tax beneficial, but obviously that's not a place with as many expats living. But so now Baleares, Valencia region, and Andalusia have all got a very good deal for group 1 and 2 beneficiaries. So that's, again, let's say the will out of the way. What happens with probate? Well, if you're thinking about buying a property in Spain, probate in Spain does not need to worry you. If you make a Spanish will with us, we always guarantee that we can go to probate and have everything wound up within 3 months. And then we always say, add on an extra 1 month for each extra property. So what I mean by this is this: because the last step of the inheritance procedure is to register the new deeds with the local property register where the property is situated. If all the properties, if you've got 3 properties and they're all situated in the same area that belong to the same property registrar demarcation, then they will all be registered within 30 days. But if you've got one in Almeria, another one in Estepona, and another one up in Aldea, then we need to add on 1 month for each extra property, because the document has to come back from the property register. I've got to send it on to the other one for it to be registered as well. If somebody is in a real hurry, you can actually get 3 authorized copies of the deed and do it all simultaneously, but it's an extra cost that's only necessary if we're in a big hurry to sell the assets. So normally what we do is when there's 2 or 3 properties in different areas, we ask the client, which is the one that you're likely to sell first? This one, well, that's the one we register first, so that it can then be sold if that's what we want to do. So as I've touched on before, regarding inheritance tax, this is a complex matter because we've got 17 regions, 7 different sets of exemptions. The good thing for people that some people don't realize, and something they're overpaying, is that if you are a non-resident, even if you're a resident in a non-EU country like Great Britain, you are now, even though you will be presenting your inheritance tax return, or well, we'd be presenting your inheritance tax return to the National Inheritance Tax Office, we are actually allowed to claim the exemptions available in the region where the majority of the estate's assets are situated, if they're more beneficial to the taxpayer, that is the beneficiary in Spain. Okay, so with all this, if you'd like to discuss your inheritance tax, the inheritance tax implications of your will, or the inheritance tax implications of an estate that you've been left, book a consultation with us. Again, we can do it over Zoom if you're not anywhere near one of our offices, and we can go through your particular case and discuss your inheritance tax situations. What I always say is with inheritance tax, that people need to be aware of the trade regarding the valuation of the real estate, that people need to be aware of the trade-off between inheritance tax and capital gains tax, which could do for a completely new video. But in my series, Inheritance from Hell, one of the worst mistakes that we see keeps coming off is properties, estates where somebody's received, say, for example, a large villa from their spouse, and they've gone and undervalued the property thinking that they're saving something. And in reality, if it's from their spouse, inheritance tax is zero, close to zero, if it's in Andalusia. So basically undervaluing it serves no purpose because there's a very small difference to notary fee, registry fee, and solicitor's fee. But remember, that will be the starting price for future calculation of capital gains tax. So, the silliest mistake I spoke about in one of my Inheritance from Hell, but we've seen quite a few, but the worst one I've ever seen is a piece of land down in Marbella area that was inherited. They valued it at €1,100,000. Then this person sold it just a few months later for €2 million. So you end up paying 24% on €800,000, which basically in extra inheritance tax would have cost him less than €1,000. Absolutely a silly mistake, but we do see this trade-off. People not taking advantage correctly of this trade-off. So just a word of caution there. Okay. So regarding the inheritance process, as I say, if there is a Spanish will, the process is relatively quick. It's not very painful. There are certain, if the deceased was UK domiciled, the Spanish lawyer will have to prepare certain certificates for the English lawyer so they can present their correct tax returns over there. And within 3-4 months, everything will be ready to sell if that is what the beneficiaries want. So what happens if there isn't a Spanish will? So this is something that you don't want. So if you're watching this video and you've got an asset in Spain, you haven't made a will, get that will done, and you'll avoid the complications. We do handle every now and again. We've got to handle Spanish estates using an English will, but it requires us then to wait for probate in the UK. Then we have to convalidate official translations. It's got a few extra expenses there, and a lot of delay, amongst other things, because probate in the UK now is taking much longer than it used to. Also, if the English will mentions the word trust, it starts getting very complex to wind up the Spanish estate. It will be done, but it will be more complex, and it may create serious problems with inheritance tax. And what happens if it's intestate? Okay, so it does happen every now and again. It is becoming very rare that somebody dies in Spain, no will anywhere. Well, if they're a foreigner, the first thing we have to determine is which law is applicable to the inheritance. Spanish law is more beneficial to children. The UK law is more beneficial to spouse. So at the end, what determines which law is applicable to the distribution of the estate, not to the formalities, because in Spain we have to follow Spanish formalities, but what law is the one applicable to determine the distribution? Well, conforming to Directive 650/2012, that's been valid in Spain since 2015, Spain is always going to apply the law of the last residence. So if you are a resident of Spain, then the lion's share of the estate is going to go down towards the kids. If you are a resident in the UK, then it will be English law that we will have to apply. But the notary here in Spain will probably ask us to provide certifications of UK law to prove to him what the English law says, so then the notary can apply it over here. The intestate procedure is more expensive and it's a longer process because the deed is not all done in one go. We have to do one deed first to declare their beneficiaries. Then the notary will publish that deed to see if anyone comes forward. And there's all sorts of things that we have to prove. So, for example, if there are no children, we've got to prove that there are no children, which is difficult. Sometimes the notary will ask us to do with a couple of witnesses. If the beneficiary, for example, if there are two children but one of them has passed away, we've got to provide the death certificate, again if it comes from the UK, with Hayes Apostle official translation. And likewise, if there was two children and a parent, and the two children have passed away, we've got to prove the two children have passed away. We've got to prove that there are no other children, so we have to bring witnesses in, and then we've got to prove the parent is indeed the parent, and if one of the parents has passed away, we've got to prove they've got. Everything has to have Hayes Apostle official translations. In other words, it's a complex process, okay? And the timescale balloons compared to probate using Spanish will. If you need help with an intestate procedure, again, contact us and we will take a look at it, go through the situation, analyze it, and if possible, provide a closed budget for the work. It's not always possible. Another disadvantage that the intestate procedure has for us and for the budgets and things is that, unlike with probate with a will, with this intestate procedure, we can't choose notary because we have to choose a notary from the area where the proper person passed away. And that, again, causes lots of problems because intestate procedures for expats are complex. Not all notaries are comfortable with, but if there's only two notaries in that area and neither of them are comfortable with us or with the process, etc., then we've got a problem, and it may all end up in court and then taken forever. So, as a summary of all this, if you're thinking of buying a property in Spain and your concern is the succession later on, don't be concerned about it. Simply buy the property, make a Spanish will. You can call us and we can help you make a will anywhere in Spain. And I say we will guarantee that within 3 months of you passing away, we will be able to wind up the estate. And we will also be able to explain in advance exactly what the inheritance tax implications will be, etc. If you've already got an asset in Spain, if you've already made a will, but you just want to make sure that it's still the best will possible, give us a call. We'll have a Zoom consultation, send me a copy of the will, and we'll either make a suggestion of a new will or tell you that everything is in good order. If you have parents in Spain that have a Spanish will or have not made a Spanish will, by all means, talk to them, get them to sort it out, and then forget about it for as long as possible. But the will is something that needs to be done. I always say that when people ask us, what are the things that you should most important for people to do to avoid legal problems in Spain? My feeling about this is that 80% of the serious legal problems that expats had in Spain would be 80% or 90% of the serious legal problems in Spain would be avoided with just 3 things. One is to use an independent lawyer to handle their conveyance. Number 2 is to make a Spanish will. And number 3 is to request bank guarantees when you buy a property under construction. Sorry, I've got off track there slightly, but from the point of view of an inheritance lawyer, someone like me that handles inheritance and probate, there's one main thing that I would recommend, and that is that if you have assets in Spain, make a Spanish will. I hope you found the video useful.